Welcome to Prince Shorthand House, dear students. This is your legal trial passage for the upcoming court skill tests. Be ready. Start. On the contrary, the plaintiff, after the restoration of the suit, filed and pursued an application for recovery of monies from the defendant and for deposit of earnings of the defendant from the property in this court, and which plea of the plaintiff was misconceived in the light of pronouncement of this court in Jeevan Das versus Naren Das, AIR 1981, Delhi 291. That application of the plaintiff did not find favor with this court also and was dismissed as aforesaid. It was only thereafter that the application under consideration was filed nearly 22 years after the filing of the written statement and 2 years after the statement of the counsel for the defendant recorded on 29th March 2006. The apex court in Jugraj Singh versus Labh Singh has held that the readiness and willingness of the plaintiff has to continue till the date of the judgment and decree. Though in Ram Awadh versus Dubey, AIR 2000, SC 860, Jugraj Singh was overruled, but on another aspect, and in fact the part of readiness and willingness of plaintiff in a suit for specific performance till decree was restated. Thereafter, it was reiterated that even after court has passed decree for specific performance, contract between the parties is not extinguished, and if it is found that the decree holder is not ready and willing to abide by his obligations under the decree, the agreement, contract can still be resigned by the court. I find that the statement in the written statement on the basis whereof decree under Order 12, Rule 6 is sought were not in admission of the averments of fact of readiness and willingness of the plaintiff, but were in the nature of a counter offer by the defendant. The defendant did not admit the case of the plaintiff, but so as to establish his defense made a counter offer. The said counter offer was not an open offer, but was limited in time of 30 days of 15 days from the date of filing the written statement. It was open to the plaintiff to accept the said counter offer in terms thereof. However, the plaintiff failed to do so. Moreover, as aforesaid, the conduct of the defendant prima facie does not show the readiness and willingness of the plaintiff during the pendency of the suit. However, the same shall be subject to finding in trial. All that can be said at this stage is that there is no admission on the basis whereof the plaintiff has become entitled to a decree for specific performance. There is yet another aspect of the matter. The plaintiff has, in application, offered to deposit the entire balance amount of rupees 56 lakhs only in this court. The counsel for the plaintiff has, during arguments on inquiry, stated that the plaintiff is now willing to buy the property with tenants and is also willing to deposit interest in terms of the agreement in this court, subject to the decision of this court. In this regard, it has to be noticed that besides rupees 12 lakhs already paid, the plaintiff was to pay rupees 25 lakhs at the time of possession and sale deed and was to pay the balance of rupees 31 lakhs with interest at the rate 1% per month within 1 year. Why such an unusual agreement was entered into is to be found during trial. However, one thing which is clear is that the plaintiff was to pay interest at the rate 1% per month on rupees 31 lakhs. The plaintiff has, however, not offered to pay the same in the application also or during arguments. Stop.